So the nature of my talk tonight is what happens when a patient sues for malpractice. So I have a lot of ground to cover. So I'm just going to get right into it. So what is a dental malpractice claim? A dental malpractice claim, simply put, is a legal claim by a patient against a dentist seeking compensation for damages as a result of alleged dental malpractice. You'll all have dental malpractice insurance to defend against such claims because obviously it's mandatory for all Canadian dentists. Each province's dental malpractice insurance policy is somewhat different, but they all have common features, and I want to talk about some of those. All the policies will have a requirement that you have a mandatory obligation to make a report to the dental malpractice insurer when you receive notice that a patient may be making a claim against you. And it's important that you understand that it's essential that you be proactive in notifying your malpractice insurer when you receive notice of a claim from a patient or a lawyer. It doesn't cost any money, so it's fairly straightforward just to make a call or send an email, and you typically don't have to pay the deductible until various steps have happened down the road. So don't be hesitant if you're worried about a claim, if you get a patient complaint to your college or association, or you get a letter or a threatening email or a lawyer's letter, it's the safest course just to get on with it. Contact your malpractice insurer, put them on notice. You don't want to be in a position where your insurance company alleges that you prejudice them by making a late report, and that's a possibility. The next related concept I want to talk about is admitting liability. So dentists in Canada must always be careful not to admit responsibility to a patient for dental malpractice without understanding what that means. And each province, again, has the same type of insurance where it provides that if you admit liability to the patient, then this may prejudice your insurance coverage. And the logic is that the insurer doesn't want you to readily admit to the patient that you've done something wrong without the insurance company being able to consider the matter. And simply because you may think that it's a straightforward matter to say to your patient, yeah, I made a mistake, here's $1,000, but the patient may take that $1,000 and come back and ask for $100,000. And if you've already admitted responsibility to the patient, then the insurance company is prejudiced. So I think it's fairly straightforward business logic. So that brings me to the next related issue, which is request for refunds. So if a patient contacts you and they complain that you've messed up their mouth or their implants have failed, don't tell them immediately that you agree that you're factually or legally responsible for their pain and suffering. That's what admitting liability means. Because if you're sued in the future by the patient and you go to your malpractice insurer to get a lawyer to defend you, then the malpractice insurer may say they're not obliged to defend you because you prejudiced their position by admitting responsibility when maybe you shouldn't have done so. So you'll be inadvertently providing evidence that assists the plaintiff in their lawsuit. And the reason for that is that the judge could interpret your statements agreeing that you were at fault as some kind of acknowledgement that you were negligent. And obviously this comes up fairly regularly when patients request a refund. The advice I provide my dentist clients in every province that I provide advice is, if you've been asked to provide a refund and you think maybe that you provided bad dentistry, then contact your malpractice insurer and get their blessing to make the refund. So the way it typically works, and the way it works in Ontario, is the PLP, which is the malpractice insurer in Ontario, will provide the form of release that you'll get the patient to sign. So the concept is that you'll give money to the patient, but in exchange, you'll get the patient to sign a release. And obviously a release is a legal document that in exchange for the payment of money, the patient gives up the right to sue you, essentially. So it's like a schoolyard swap. You'll get the patient to sign a release, you'll pay the money, you get the release, give it to the PLP. Of course, you should only consider refunding money if it's clear to you that you've made a mistake or provided negligent dentistry. I find with patients these days, they're quick to ask for refunds in circumstances where they probably don't deserve a refund. The patient will often try to pressure you into making a payment when you might not have done anything wrong. And my advice, it's a difficult issue. If you're unsure of whether you've acted negligently, then get some advice from a colleague or your principal or your malpractice insurer or your lawyer if you have a lawyer who has experience in these areas. Because if you consider that the dentistry wasn't done well and you may have caused the patient pain or expense, then a refund in exchange for a release might be a good idea, because it will shut down the risk of getting sued and perhaps shut down the risk of getting a complaint against you as well. So that's the next area I wanted to talk about, is the role of patient complaints to your college. Because there are two separate concepts. There's a lawsuit against you, which is in civil court, which your dental malpractice insurer responds to, but then the patients often complain at the same time to your college saying that you've committed acts of misconduct. So it's something I'm very familiar with. So a certain percentage of complaints to the college will also lead to a dental malpractice lawsuit as well. So I think it's important for you to understand the interplay between these two separate events, because I know that lawyers who sue dentists for malpractice often encourage their patient clients to make a complaint against you as well to your regulator. Why do they do that? First of all, it's free. It doesn't cost anything. But secondly, it causes the dentist to have to respond to the complaint. And if you do a proper response to a patient complaint, that will provide the factual background for what happened. And the plaintiff's lawyers sitting in the weeds waiting, the plaintiff's lawyer will be able to see exactly what your position is concerning the dental issue, and they can use your response to sort of fashion their tactical approach to the lawsuit. So if you have a patient complaint, make sure that you're consistent in your response and that you put your best foot forward. You put considerable thought into how you respond to the patient complaint, especially if it's one where it's alleged that there was a lot of pain and suffering or that the patient suffered. So if you describe what happened in this response, you must understand that version of events will follow you if you're sued in the future. And what I mean by that is, let's say you write a response to the Manitoba Dental Association, responding to a complaint, and describe a version of events, a conversation with a patient or an observation that you made, then you get sued. You can't very well change the factual narrative because you've already gone on the record and told what happened in your own words. So you need to be consistent. Many patients think that when they complain to the college, they're going to get money back. And obviously that's not correct. None of the colleges in Canada have the legal ability to order a patient to receive a refund from a dentist or to order you as a dentist to give the money back. If that's the patient's expectation, they'll be disappointed. But I regularly see this. They think that, this is the way for me to get back at this person to get my money back. But it doesn't work like that. But in the complaint process, there's often mediation offered. So some of the colleges, Manitoba and Alberta and BC and Ontario at least, have a mediation or dispute resolution process that involves the dentist and the patient engaging in in-person or virtual mediation. And if you're offered this in a complaint, please consider it. Because if you can resolve a complaint by paying a nominal sum, you can likely get the patient's signature on a release as well. So you'll kill two birds with one stone. You'll get rid of the college complaint, but you'll also get a release which will preclude the possibility of a malpractice claim against you. It's a good idea to have legal advice if you're engaging in a mediation process, because you need to value the risk to you from the patient's claim. So the patient has an unrealistic expectation. They want $50,000 to resolve a complaint, and their claim is about 2 restorations. And you know that that's too much money, and you need to get advice about what's a reasonable sum to pay. What I find with mediation is that most patients who attend, and it's all virtual these days, who attend mediation consider that this is their day in court. So there's some kind of cathartic process where they get this weight off their chest, and the mediator listens to them, and they're happy to resolve things, or they're willing to resolve things. So if you could handle the mediation diplomatically and give some kind of qualified apology, then this can go a long way to soothing hurt feelings and resolving the patient's grievance. So please consider it. If you're offered mediation or ADR, consider it for the reasons I articulated. That is, it gets rid of a complaint, but it also may get rid of the risk of a malpractice proceeding. So what are the mechanics of a malpractice claim? It's a lawsuit typically brought by a patient claiming damages for negligent dental treatment. The patient claims something called general damages, which are damages awarded by Canadian courts for pain and suffering. And this is typically by far the largest component of any dental malpractice settlement or judgment against a dentist, is damages for pain and suffering. The next component is what lawyers call special damages. So the patient's going to want you to refund the money they paid for their implant and prosthetic case. And they also may want money for the repairs that have to be done, that they have to pay another dentist, and they may also claim income loss and other expenses. And if they're represented by a lawyer, they'll be looking for a contribution towards their legal costs. One of the questions we receive in advance is, what do you have to do to sue a dentist? And typically, the first step is for a patient to retain a lawyer. It is possible for a patient to sue a dentist without getting a lawyer, and you see this routinely in small claims court, but for the most part, it's lawyers who will be showing up on these dental malpractice claims. But you must know that dentists do get sued in small claims court for dental malpractice, and I've seen a number of cases where the dental malpractice insurer pays a lawyer to defend you in small claims court. And it's still a pain in the neck, even if it's small claims court, you still have to go there. Small claims court is quite disorganized, and you end up waiting around a long time until the case gets reached. So if you can avoid it, you should. Just a quick review of litigation steps. Every lawsuit is started by a document called the statement of claim that sets out the plaintiff's allegations. You then, when you get served, you're obliged to file a statement of defense within 20 days of being served with the statement of claim. So if you get served with a statement of claim, immediately send the statement of claim to your malpractice insurer. The malpractice insurer will typically step in. They'll either call the plaintiff's lawyer and ask for more time, or they'll send it to a lawyer to defend you and to draft your statement of claim with your assistance. So some of the other steps are the parties will exchange documents at some point through a process known as affidavits of documents. You then attend examinations for discovery. So you see on television American depositions. This is the Canadian version of a deposition. You go to the court reporter's office, your lawyer examines the plaintiff under oath, then in turn the plaintiff's lawyer examines you under oath. So it's a pretrial procedure, and again, the name gives it away. The purpose is to discover the other side's position. Most cases settle after discoveries, although this is never guaranteed. Some cases do go to trial. So in terms of an explanation for what you have to prove in a dental malpractice case, the plaintiff has to prove that the defendant dentist fell below the standard of care demanded of him or her in the circumstances. So what's a standard of care? It's basically a variation on what you may know as the standards of practice of dentistry. So every province has standards of practice, published or unpublished, from their college. So in the College of Dentist Discipline Proceedings, the language they use is you breached the standard of practice demanded of you. The plaintiff in a dental malpractice takes the same approach. That is, they allege a breach of standards, but they call, in civil litigation, the courts utilize this standard of care as opposed to standard of practice issue, but it's the same standard. There's only one way the correct way to practice dentistry, and whether you call it standard of care or standard of practice, it amounts to the same thing. The plaintiff has the burden of proof, meaning they have to prove their case on a balance of probabilities that the defendant dentist's conduct fell below the standard of care demanded of a reasonable dentist in all the circumstances. So how do they do that? Typically, the standard of care, or what the dentist should have done, will be established by expert evidence that the plaintiff's lawyer will have to call through an expert dentist. Dental malpractice claims are a type of negligence claims. So negligence is a broader legal concept than dental malpractice. It's known as the tort of negligence. It simply provides that you owe a duty of care to your patient to provide dental treatment in accordance with the standard of care demanded of a reasonable dentist in the circumstances. And how do you prove breach? It's also typically necessary to get an expert witness, an expert dentist, to come and show up, say, look, I've looked at the records, I've looked at the x-rays, I've looked at the CAT scan, looked at the models, and I think that the defendant dentist was negligent. They failed to meet the standard of care because they didn't get a proper CAT scan, they didn't do this test or that test. That's how you prove standard of care being breached. It's obvious that you owe a standard of care to your patients to provide competent dental care. So it's not sufficient for the plaintiff to simply stand up and tell their story and expect the court will say, yes, the defendant dentist was negligent. The plaintiff must establish what the appropriate standard of care is, and that the defendant dentist fell below the standard of care in the circumstances. So in lay terms, it just means the plaintiff is going to have to prove what you should have done, and then the judge is going to have to decide whether the plaintiff has satisfied the judge that you were negligent or not. And if you're successful in proving that the dentist fell below the standard of care as a plaintiff, the plaintiff still has to prove that the breach of the standard of care caused the damages claimed by the plaintiff. So I was asked to provide a list of the types of malpractice claims that I've seen. And this list is obviously, the list is only limited by the factual circumstances. And you all will have heard from colleagues or from your own experience, situations where dentists have been sued. And some of these are not huge claims. Recommending unnecessary restorations, it won't be a huge claim because the patient won't have suffered that much by getting unnecessary restorations and won't have paid a huge amount of money. failure to put a crown on a root canal treated tooth leading to a tooth fracture, leaving a separated instrument in an endodontically treated tooth, excessively restraining a child using a papoose board or other restraint. What you get sued for if you do that is for something called battery, which is a form of assault. So the parents allege when they see you strapping their screaming kid to the papoose board, they think you're assaulting the kid and they sue you. And I see those types of claims. Again, they allege that you physically assaulted the kid when obviously you were trying to restrain the child for their own good. Failing to identify a child's cancerous tumor in a timely manner. That situation I saw on a file a couple of years ago, that the child, it was a boy who was 14 years old, and he had some worrying signs in his mouth. The GP dentist client of mine didn't identify them and didn't refer the patient out, and it developed into a full-blown cancer. And my client was sued and was also found to have been guilty of misconduct. Failing to advise a patient of a risk of a recurrent ameloblastoma. So in a former life, up until around 25 years ago, I occasionally sued dentists on behalf of plaintiff patients. I stopped doing it a long time ago because my bread is buttered on the dentist side now, and I don't do that anymore. But this is one of the last cases I did. It was a tragic case of it. My client was a young guy, probably in his early 20s. He'd had some signs of an earlier ameloblastoma, but the GP dentist and the oral surgeon that were monitoring him missed the further signs, and as a result, a lot of his mandibular jaw, I think on the left side, was removed, and it was a horrible case, and he got a decent settlement. Providing a patient with excessive sedation amounting to an overdose, improperly placing implants without the pre-treatment investigation, failing to take a CT scan before placing implants, extracting an excessive number of healthy teeth to facilitate implant treatment. I've seen cases where 12 or 18 or 20 teeth are extracted to facilitate a treatment plan, and it turns out it's the wrong treatment plan. This is a case I had in Alberta, improper use of zygomatic implants. This was a complicated case. Zygomatic implants are somewhat lesser known form of implants, but they have their uses. And in the same case, the dentist was accused of puncturing the sinus during implant treatment. Failing to warn a patient about the risk of root resorption. Obviously, that's an ortho case. That one of the cases I had led to a patient having real trouble. Orthodontic treatment causing permanent jaw damage. Patient swallows a burr. Patient falls out of chair when over sedated. I mean, it's a form of negligence, but it's not dental negligence. It's like, you should have watched the patient more closely and not let them fall out of the chair, basically. Patients burned by materials during restorations. Dentist breaks patient's jaw during complicated wisdom tooth extraction. Dentist severs the lingual nerves on both sides of the patient's mouth during the extraction of the lower wisdom teeth. That was a terrible situation. I couldn't get any expert to justify what my client did in these circumstances, because I think the regulator in that case said that there were worrying signs on the X-rays that should have convinced my client to send this person to an oral surgeon, as she was a GP. Failing to adequately warn of the risk of paresthesia. Obviously, there can be minor paresthesia, but there also can be far more serious facial paralysis in circumstances where somebody has a public-facing job where their face being numb would be an incredible impediment to them and cause them significant damages. I have a specific section in this talk on implant dentistry, because dental implants are a growth industry, both for dentists, but also for plaintiffs' lawyers as well. I know that more and more dentists, more and more GPs want to do implant dentistry. It's more interesting than the regular work that you do, and it can also be more lucrative. And so you get the training and you're qualified to do it, but sometimes it goes wrong. Some of the dentists are not doing a good job, and they're getting sued and they're getting complained about. And I think it's a relatively high risk type of dentistry if you're not sufficiently trained, or if you're too aggressive in your case selection. And what I mean by that is you recommend implant and prosthetic treatment for patients who are not good candidates. That's the biggest problem I see. I do a lot of cases at the college here. And there's a gradual increase in the number of regulatory complaints arising from failed implants. Unfortunately, that means this is also a fruitful area for dental malpractice lawyers. Why? Because implants are expensive, and they're usually part of a more extensive prosthetic treatment plan. And I've seen cases that patients spend $40,000, $60,000, $80,000 on a really complicated multiple implant and prosthesis case, and it goes wrong, and they want their money back, and they spend lots of money fixing that, and they have bone loss and pain and suffering, and then they sue. It's not pretty. The more money a patient spends on dentistry, I find the more they're likely to sue if the dentistry goes wrong, because they have an expectation that is not met. So in Ontario, we have implant guidelines that are helpful. They simply provide, they provide lots of things, but they divide cases into straightforward placement of implants and then complex placements. There are different educational requirements for each type. But the biggest problem I see is poor case selection. Dentists who recommend implant dentistry for patients who are not good candidates, whether it's because of poor oral health, soft bone, low bone levels, or a complicated implant and prosthetic case that requires the patient's participation in looking after their implants, and they're no good at that. That's a problem. So it's obviously also essential that you do a proper diagnostic workup before you place the implants. So be careful. If you want to do the work, just make sure that you have sufficient training and you have support if it's a complicated case. I wanted to talk about informed consent. One of the questions we were asked is whether it's necessary to have a written informed consent form for dental procedures such as restorations or extractions, or is oral consent sufficient? Lawyers always like to say this: informed consent is a process, not a document. And what that means is that it's important to demonstrate the patient understood the risks of the procedure. It's not necessary to have a written informed consent form for every procedure, but in Ontario, at least, the regulator expects that you will have some record of your informed consent discussion with the patient in your notes, even if you don't have a written informed consent form. Typically, the requirement for documented consent for basic restoration, for example, is much less than other procedures. But if you're doing a restoration that and it's going to be a large filling, and there's an increased risk of a root canal procedure following the restoration, then your note should probably reflect that you warned the patient of the risk of a root canal procedure. It's a common complaint that occurs. I just worked on a case like that at the College of Dentists here. The patient's mother, the guy was a teenager, he had bad caries. She complained that he required a root canal treatment after restorations, and she wanted my client to pay for the root canal treatment. But the child had a bad oral hygiene history, and my client had told the mother on 3 separate occasions that he's recorded in his notes that the caries was so extensive that when the tooth was restored, there was an increased chance of a root canal treatment. And that's an example of even doing a restoration where you need to get a good informed consent. But in that case, the note was quite simple. This is what the guy said: showed bite wings, advised upper left deep, may need endo. And so there's a variation of that in 3 separate occasions. And I'm satisfied that meant that the mother understood that there was a risk of root canal. In my opinion, any implant case of any size should have a written informed consent form, any crown and bridge case as well. And you should also address the financial cost to the patient as well. Written informed consent forms or a detailed treatment plan that breaks down the cost of each particular step are very useful, because if a patient signs the informed consent form or acknowledges receiving the written treatment plan, then they're not able to say in the future that they had no idea how much it was going to cost or what treatment was being provided. I also think it's a good idea to get written informed consent forms for sedation procedures and for extractions, both for adults and for children. The issue with respect to extractions, I find, is that adjacent teeth get damaged, nerves may get damaged, patient may suffer dry mouth or an infection. All of this can be painful, and it's helpful to have an informed consent form that reflects that you warned the patient of the risks of these types of things, including paresthesia. And you should also put on this form that the patient should contact you immediately if there are any complications. There's a number of cases I find the patient has terrible problems. They go to emerge, they have some allergic reaction or some horrible reaction, and the dentist doesn't find out till much after the fact, because the dentist didn't clearly identify to the patient that they should call them back if there was a problem. So the reason I'm talking about informed consent in such detail is that you could be held liable in a dental malpractice proceeding if you do the procedure in a competent fashion, but an adverse event occurs just because of the patient's physiology. Something goes wrong, an infection happens, an implant fails. And if you didn't warn the patient in advance of this material risk, then you may be liable to the patient for damages because you didn't get an informed consent from the patient. So that's an aspect of dental malpractice you have to be careful of. In terms of the informed consent process, it's important to understand that even if you have a really detailed form, informed consent form that's been signed, you need to demonstrate that you reviewed the form with the patient. And that's why lawyers say it's a process, not a document, because a judge may not accept that you obtained an informed consent, because patients are notorious in saying, well, I signed it. I was in a rush. I was in a rush that morning. The dental assistant discussed it with me for 30 seconds. I didn't know what I was signing. So that's why I always talk about the cliche that it's a process and not a document, because you need to demonstrate that the process was followed, that the patient understood what they were being told and what they were signing, especially if the patient doesn't speak English well, or frankly, the patient isn't very intelligent and you're doing something that might be somewhat complicated. You need to demonstrate that the patient understood what treatment was being provided and that you have a record of this consent discussion. And there's just some general concepts about informed consent. It's a difficult area. You're supposed to disclose material and special risks. The materiality of a risk is measured by the gravity of the outcome. Minor risks should be disclosed if there's a substantial likelihood. Again, this is somewhat legalese. Some of it may stick with you, some of it may not, but not every remote possibility needs to be disclosed. It's also necessary to discuss alternative treatment. Then the next topic, how to avoid getting sued. And again, that's a very broad question. I can't give you unrealistic advice never to make a mistake, but what can you do to lessen the odds of being sued? I guess there's two related issues. Mistakes are going to happen. Dentistry is full of risks, and you can't avoid some treatment failing no matter how careful you are. But what I find is pay attention and be empathetic. And maybe that's strange advice coming from a lawyer. Lawyers don't have a great reputation for being empathetic, but patients are far more likely to sue you or complain about you if they don't like you or think you don't like or care about them. They may forgive you for mistakes if you have a good rapport with them. And I have a client, this client has had 12 regulatory complaints against him in the last 10 years because they're not nice to their patients. They're rude to them, and anytime anything goes wrong, the patient lashes out at the dentist because the dentist is not nice to them. So it makes a difference. Get involved, call the patient, take an interest, because patients will lash out at you if they don't like you or they think you don't care about them. And it's a problem. Or if you're indifferent to their pain. And I find some of my clients are very good at being warm and fuzzy to patients. If you're not in that select group, then you need to fake it, or you need to at least make an effort or think about being nice, to show empathy, to be nice to your patients. And when you're aware a patient is unhappy, get involved. Don't leave it to your staff. Pick up the phone, call the patient back, ask them how they're doing. In this way, if the patient has a negative experience, they may not seek retribution because they like you and think well of you. And it's a really basic proposition, but in my experience, it's true, because every complaint and every lawsuit reflects a breakdown in communication between the dentist and the patient. And the patients tried to call in and discuss things, but they haven't got a good response. Now, some patients will never be pleased and they'll sue you anyway, no matter how nice you are. Some claims are unavoidable, but some claims can be addressed if you have a disgruntled patient and you deal with it properly. And these are situations where your direct involvement could neutralize the problem. The patient calls and complains, what's your current practice? Do you call them back, or do you leave that issue for your staff? When do you choose to become involved? I find with associates, the problem is that the employees of the dental office may not even tell you that Mrs. Smith has called in and she has a problem with what you did. You need to make sure as an associate that you're notified about any potential problems before it mushrooms, because there are very few cases where the patient makes no effort to address the grievances with the dental office. Usually they call the office looking for compensation or complaining. That's really the time to act. Don't assume you could delegate this. People at the front desk are not the ones who are going to be sued. They may not understand the nature of the problem. They're not the ones who are going to stress out. So be proactive. Try to take the time to reach out to the patient, have a dialogue, make notes of what you discuss. And I think empathy and a qualified apology may go a long way to diffusing hurt feelings, which is what leads to lawsuits and regulatory complaints. I know you're thinking, well, this is another lawyer telling me to do things that are unrealistic, telling me to do things that take too much time. And there's not enough time in the day to do that. But just keep in mind that the time you waste getting sued or getting complained about, how many hours you're away from your practice, how much time you have to spend with your lawyer, which is never a good thing. And patient complaints are also time consuming to deal with, and you might have to pay legal fees. And it stresses you out. It's a miserable thing to undergo. So if you can avoid it, then do so. Two final points in closing: the importance of good records. This is something you were taught in first-year dentistry. Your notes are your best friend. Your notes will be the first line of defense if you get sued, because obviously you can't remember every patient visit or every step. So your notes are supposed to refresh you, because you could be in the witness stand from something that happened 8 or 10 years ago. So if you don't have good notes, it'll be very difficult to defend a dental malpractice claim that may depend upon things that happened a long time ago. You need to make sure that you record all clinically significant details. That's a cliche as well. The problem is that judges and discipline committees take the approach that if you don't write something down, then it probably didn't happen, because they know that a dentist can't remember something from 8 years ago. The dentist shouldn't be believed in giving self-serving evidence of suddenly remembering something that's not written down. So they're skeptical. So try and do your best with your notes. In conclusion, one final point we were asked is, can you countersue? So dentists always complain, well, I've been sued and I want to make a claim against the patient. I'm upset. My spouse is upset. I can't sleep. It's not a good idea to even think about a counterclaim. These types of things are not recognized in law, and your defense insurer is not going to want you to make a counterclaim for your subjective suffering as a result of the plaintiff suing. You won't be considered a victim. You won't engage the court sympathy by complaining how unpleasant the process has been for you, even if it is unpleasant, and I accept that it is. Ultimately, these claims will come to an end, whether it's the patient giving up or discontinuing, or the case settling, or the case going to trial. 99% of these claims never get to trial. Although there's an occasional case where the insurer will say, well, the claim seeks damages over your insurance policy limits. It would be a very rare case where a dentist would have to pay any money out of his or her own pocket, because you have, depending on what province, either $2 or $3 million of insurance, and then you may have excess insurance as well. So you will survive these types of claims. It's just, I'd like you to stay out of that experience and not go through it. Your career will continue. It's not a career-ending thing. It's just an unfortunate part of the cost of doing business that you can be sued. But as I said, it's not career-ending.
What a great presentation. So we all know now what happens when you are being sued. So my portion of the presentation is going to be just give a general idea of the plan you have. For dentists outside Ontario and Alberta, probably you all have coverage with us. So the malpractice insurance that you have offers different limits. The minimum limit is 3 million. You can go all the way to 25. You also have your legal fees are covered under the plan, and the amount is above the limit, so it's not included on your malpractice limit. I always get a question if you can choose your own lawyer in case you are being sued for malpractice. The insurance company Zurich has vetted a series of lawyers across Canada in different regions and major cities. In doing that, they make sure that the office, the lawyers, they are experienced, they are successful, they are litigation lawyers, and they understand malpractice and dentist. However, you do have the option, but you're going to need the approval from the insurance company. So if you're ever in a situation where you are being sued, you talk to the adjuster, let them know that you have this lawyer that you would like to defend you. Zurich will do their own due diligence to see, they want to make sure that you are getting an expert in malpractice claims. So don't just go hire the lawyer and then let the insurance company know, get the approval first. And you're also be reimbursed for the time that you spend in court, like Matthew said, in discovery, pre-trial, and if it goes to trial, $400 a day with a maximum of $1,600 per claim you are entitled to get. Your plan also insures the your corporation. So you don't need a different policy. You don't pay an extra premium to have your corporation insured. Just let us know, give us a call. We add the corporate name to the policy. Now, don't panic if for some reason you are now facing a claim and you forgot to let us know that you are incorporated. Our policy wording does cover automatically any interest that you have or had in a corporation. So it's just a matter, it's easier, it's cleaner in a claim situation to have all the corporate names. We do have clients, for example, they are licensed in different provinces. Each province has its own corporation. And this is not an issue because other than Alberta, Ontario, and Quebec, your malpractice goes with you wherever you go, as long as you are licensed. So you just need to notify us that you are getting licensed in another province or territory, provide the new licensing body the confirmation of malpractice of CDSPI, and you are good to go. So you don't need to have an extra coverage, it goes with you. Now, I get this question all the time, and this is where it is important. How much coverage do you need? Well, there is no magic formula. Usually what I tell my clients, first, it's a level of comfort, your patient demographics, specialty, type of procedures that you typically perform in the office. Usually, the way I see is the more extensive and the more complicated the procedure, the higher the chance that something is going to go wrong, and you may end up being sued. So our minimum limit is $3 million. So all dentists outside Ontario and Quebec, they start with 3. Just so you know, now PI has increased their minimum required to $5 million. I'm seeing a lot of clients increasing from 3 to 5 because the difference in premium it's around $109 a year. If you go from 3 to 5 million with an aggregate of $15 million per calendar year. And then when you are on the 5 million level, if you decided to go to the 25 million, then the difference in premium is $692 a year. This is for 2023 premium. Always keep in mind that you are not getting insurance for the small stuff. You want to ensure that you have the right protection for those losses that are catastrophic. We always say you just need one huge loss. And you do the same procedure over and over, year after year, and there is no glitch, nothing happens. And then one day, for some reason, something goes wrong, and you may end up having a big loss. That's the loss that you want to be protected for. So I have lots of clients, they are not even specialists, that they are going with the 25 million. Are they going to use? Are they going to exceed this limit? Probably not, but it's just peace of mind. We did have a few cases where the claim, the settlement was over the limit that the dentist had in malpractice. So you don't want to be in this position, right? So the current premium, for example, for $25 million of coverage is $2,610 a year. So I think it is, for 25 million, an aggregate of 75 million per calendar year, I think it's worth. It's just a peace of mind. Now, we also have additional benefits on our policy. We have what it's called non-practicing status, meaning your malpractice goes with your license. As long as your license is active, regardless of you seeing patients or not, you have to keep your malpractice active and pay the premium for. However, when you change the status of your license, and can be retirement, can be you're going on a sabbatical for a year, 2 years, you are on mat leave, or in case of total disability, just notify the licensing body or your intention, let us know, and we change your malpractice to a non-practicing, where you're still going to be protected for any claims that may arise in the future, but you are not going to be paying any more premium. We also offer coverage for hygienists, certified dental assistants, dental therapists, and dental nurses. There are some conditions for their coverage, so it is important when they apply with us, it's $2 million per claim, that they read the policy wording. They need to be working under the supervision of a dentist. So at the present time, for example, independent hygienists are not covered. They need to be working in the dental office under the supervision of a dentist. We protected both you personally and your corporation. We are able to remove the exclusion that for a brief period of time was in our policy, no infectious disease exclusion, and no oral disease sublimit. And again, the maximum amount would be 75 million of aggregate. Now, for those clients in Ontario and Alberta, so you do get your malpractice with your license. The limit that you get is $2 million. If I'm not mistaken, there is an aggregate of $4 million per calendar year. However, you can get the excess coverage with CDSPI. You could purchase, for example, an extra 1 million that would take you to the same basic limit of all other dentists in Canada other than PAI, and an excess of $1 million, the annual premium is $73. Or you can go all the way to a total of 25 million, getting 2 million from the primary policy, 23 million under the excess. Now, keep in mind, our excess policy follows your primary policy. So it's very important for you to read your policy, the conditions, the limitations, the exclusions, because if it is not covered under your primary, the excess is not going to cover either. Also, we do offer the non-practicing status for those dentists in Alberta and Ontario, as long as the primary policy is also in a non-practicing. In Ontario, I think it is indefinite. So once you retire, there is no time frame. You are put in a non-practicing. So for those clients in Ontario with excess with us, the non-practicing stays as long as the primary is also non-practicing. In Alberta, it looks like it's for 10 years. So you will have non-practice with us for 10 years. We don't know what it's going to happen. This is new. So who knows what it's going to happen in 10 years. But always remember, your excess policy with CDSPI follows your primary. Now, there is a checklist, for minimizing the risk, like Matthew said. Know your patient, interact with them, be compassionate, build up a relationship. Know your skills limit. Don't be afraid to refer if you think it's way above what you can do. Don't make promise to the patients because they are going to say, but you promised, so don't do that. And again, like Matthew said, screen for oral cancer and chart. Your notes are the most important thing that you can do. It's your first defense against lawsuit. Informed consent, patient's privacy, document all continuing education, and have your insurance. Now, like Matthew said, you can do everything by the book. You follow the protocols, you follow the procedures, you didn't do anything wrong, and you end up being sued or a patient complaining. So what do you do? And this is what Matthew said on the beginning of his presentation. Report to CDSPI any situation that may arise to be a claim. Can be a conversation the patient had with the front desk. Sometimes they have a good relationship with your office manager, with the receptionist. I don't know, they have kids and they play outside the office environment. So they may feel more comfortable complaining or saying something to them than to you. That's why it's important to keep the communication open between front desk and your office. Can be a phone call, can be a comment the patient made it to you before leaving the office, can be an email, can be a call from another office asking for the records, can be a lawyer's office, or you can be served. So it doesn't matter any situation. And I had a client 2 weeks ago, he said, Renata, the patient didn't say anything, but I have this gut feeling that they were not too happy when I finished. So I'm just calling you to let you know. And why this is important. We open the claim, doesn't cost you anything. It doesn't go to your history. The adjuster will contact you. They will get all the information while it's fresh. And then they wait. Most of the time, it doesn't go anywhere. The file is closed. But if it goes in litigation, the adjuster was able to gather all the information, to see the records while it was recent and not, 2 years down the road. Your policy also allows you to refund the treatment. Reimbursement of fees are not covered under your malpractice. It is an exclusion. However, talk to the adjuster. They will guide you through the process and also provide you with the release, the waiver. So the patient will sign where it says you didn't do anything wrong, but here it's, the refund of your treatment. Always follow the guidance of the adjuster. Also, your policy allows for mediation. So in Alberta, in BC, they do have mediation, but always before you go, let the insurance company know that you are following that route with the mediation and follow the adjuster's advice. They have been doing this for years. They know the policy, they know the process, they know the procedures, and they guide you through all this. One thing that I want to make just a really important point, read your contract. Be aware, as any other policy, there are exclusions, conditions, and limitations. And one thing that Matthew said on his presentation about the abuse can be physical abuse, so mainly with a child as a restraint. Your policy actually excludes any abuse. So it's not only molestation or sexual harassment, can be any corporal punishment. So be very careful with this. Your policy does not cover. So it is important to read the contract and be familiar with all the conditions and mainly the exclusions. And if you have any questions, if you want to go through, just give us a call. You have, our email address, our phone, my name. So use your resources that would be with CDSPI.